Hello and welcome. This is another in the 10-minute tip series of recorded programs for credit and collection professionals. This program is titled To Sue or Not to Sue? That is the question. My name is Michael Dennis. I will be the presenter today. Let's go ahead and begin. Introduction. Please make a few assumptions. Let's assume first that a customer owes you money and that customer, that debtor, cannot or will not pay the outstanding balance. Let's also assume that you've exhausted all of your in-house efforts to collect that past due balance. Please also assume that for whatever reason, you've decided not to place the account for collection with a third-party commercial collection agency. That leaves us with a decision, and the decision here is whether or not we're going to simply write off the unpaid balance or alternatively sue the customer for payment. Now, it turns out the decision about whether or not to sue someone or a company for payment is complicated. And in this presentation, I'm going to examine with you how to make a better informed decision about whether to sue or not to sue to collect payment. I want to talk about fees because it's going to cost money to try to collect a past due balance. Because if you sue, you're likely going to need to hire an attorney. And this is true even if you are lucky enough to be a company in which you have an attorney on staff. Basically, the only time you're not going to need an attorney is if the debt is so small that you can sue in small claims court to recover the money owed. So let's assume that you're going to need an attorney. With that in mind, you're going to be charged by the attorney fees for their time. For example, the attorney might, in theory, charge you a fixed fee to handle the entire litigation to collect your money. It's unlikely that an attorney would charge a fixed fee because this is not the type of legal work that lends itself to the attorney charging fixed fees. In theory, an attorney might charge you for their work on an hourly basis. And quite honestly, it's commonplace for this type of civil litigation for an attorney to charge you on an hourly basis for the work that they perform in preparation for the trial and at trial. It's possible, but I would say unlikely, that an attorney might agree to accept a contingent fee for the work that they perform. And in this scenario, and this is just a hypothetical, an attorney might agree, in theory, to accept 40% of the amount that's collected as the contingent fee in connection with handling the case. But again, contingent attorney fees are uncommon in this type of civil litigation to collect a past due balance. Should you sue? A very important factor to consider is the debtor's ability to pay the money owed if you win the case. What often happens, unfortunately, is that creditors sue, they win, and they find out later that the debtor doesn't have the money to pay. The credit decision maker, the credit manager, needs to know what their attorney thinks about the strengths and the weaknesses of the case that they have, along with information from their attorney that involves reasonable estimates about the litigation-related costs as well as the timeline. How long is it going to take and how much is it going to cost to go to court to litigate this matter, to hopefully win and get a judgment that will result in the company getting paid the money owed by the debtor. The problem is that even if you win the case, it might be difficult for you to enforce the judgment that you have against the debtor company. Therefore, the risks of suing a customer to collect a past due balance include the fact that you're going to have out-of-pocket costs, including but not limited to attorney's fees. Another risk is the uncertainty about the outcome of the case. No matter how strong you think the case is, it's going to be evaluated by a third party, maybe a judge, maybe a jury, but the fact is you might lose the case. And a third risk is the uncertainty concerning the collectability of a court judgment, assuming that you win the case. One key to success as it relates to litigation to collect past due balances. My position is this: the credit department needs to take an active role in managing all of the process, including all of the risks associated with a lawsuit to collect a past due balance. Ideally, before you even begin the process, you know whether or not the debtor has significant non-exempt assets sufficient to pay the balance due, and you would ideally want to do that before you spend any money suing the debtor. Because if the debtor doesn't have the money to pay you, there's little incentive to litigate. If you don't know if the debtor company can pay before you file the lawsuit, you want to find out that information as quickly as possible. And with that in mind, I would encourage you to ask or instruct your attorney to find out as early in the discovery process as possible whether or not it's likely that the debtor is going to be able to pay you if your company wins the case. And if the answer is no, or the answer is maybe, then you'll need to make an informed decision at that point about whether or not to proceed with the litigation. And the alternative, of course, is simply to drop the case. If the debtor cannot or will not pay. Question: what happens if you win the case and the debtor will not pay you? Well, the answer is that you as a judgment creditor can request from the court what's called a writ of execution. This writ of execution is an order directing a police officer, a bailiff, a sheriff, or the equivalent, to seize and sell assets owned by the debtor, and then to take those assets and sell them, and from the proceeds of the sale of the assets to pay you the money that was owed in the form of a judgment against the debtor company. With that in mind, the last part is if there are any excess funds in connection with selling the assets, those funds would be returned to the debtor company. Again, the problem is that often the debtor company simply does not have sufficient assets to pay the debt. And as a result, you as the creditor, or us as creditor companies, end up with a judgment for money damages that cannot be enforced, cannot be collected. And please keep in mind that all along you are racking up, you are incurring on an ongoing basis attorney's fees, and you're responsible for paying your attorney for those fees, irrespective of whether you win or lose the case, and irrespective of whether or not you are able to collect the judgment that you have been awarded by the court that heard the case. So it turns out that about 95% of civil litigation cases are settled. They're not adjudicated. They don't result in a judgment by the court or by a jury. They're settled by the parties. Often, settlement discussions occur only after significant legal expenses have been incurred by one party or by both parties for things like discovery and pretrial motions and pretrial conferences. The good news is that creditors can achieve far better results and reduce the amount of fees that they incur with a disciplined approach to litigation referred to as case management. Case management begins with an in-depth evaluation, a risk assessment, if you will, in connection with the decision whether or not to proceed to litigation. That case management initial review would involve three primary steps: assessing the strengths and the weaknesses of the case, evaluating the cost of litigation and the potential benefits of litigation, and an evaluation or assessment of the likelihood that a judgment against the debtor will be collectible. So that's the initial analysis. Case management also requires ongoing disciplined reviews on a periodic basis of the costs and the benefits of continuing with litigation against the debtor to collect the unpaid balance. I want to thank you for your time and attention today. I hope you found this program to be interesting and helpful.